95321 to the American Express Service Europe Limited, number 730580, for onward credit to your American Express Bank, New York. Card account number 374588216836009. And you thereby committed an offense contrary to paragraph 3 of part 1, fifth schedule, to the Constitution of the Federal Republic of Nigeria as amended, and section 7 of the Code of Conduct Bureau and Tribunal Act as punishable under paragraph 9 of the said fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended, and section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act. How do you plead?
Not guilty.
The last count charge, count 13. That you, Dr. Olukola Abubakar Saraki, on or about 16 September 2003, within the jurisdiction of this honorable tribunal, did make a false declaration in asset declaration form for public officers upon assumption of office in the year 2003 as governor of Kwara State by your refusal to declare your leasehold interest in number 42 Remi Fani Kayode Street, Ikeja, Lagos, which you acquire through your company, Skyview Properties Limited, from First Finance Trust Limited, on 12 December 1996, and you thereby committed an offense under Section 15, subsection 1 and 2 of the Code of Conduct Bureau and Tribunal Act. Count C-15, Laws of the Federation of Nigeria, 2004, and as incorporated under paragraph 11, subsection 1 and 2 of part 1, fifth schedule to the Constitution of the Federal Republic of Nigeria, 1999, as amended, and punishable under section 23, subsection 1 of the Constitution of Code of Conduct Tribunal and Bureau and Tribunal Act, and as incorporated under paragraph 18 of part 1, fifth schedule of the Constitution of the Federal Republic of Nigeria, 1999, as amended. How do you plead?
Mr. Chairman, just as I said in the opening, just as I said in my opening comment, as against Section 3, the Code of Conduct Bureau, this is the first time this is being brought for me. And the law says that before now it should be brought for me, and before me it should not be brought for a tribunal. I just want to put down records. I plead again, not guilty. We have institutions, your institution, judiciary, and the Senate that are attest today. And I pray that in the interest of this great country, we both do the right thing that is necessary to put this country forward. And I plead not guilty. I thank you.
My Lord, he pleaded not guilty. Thank you.
The issue of law that was raising while taking this plea, because those laws, according to himself, were based on wrong advice, because and they are contrary to the ruling of this court. He has raised this point that is raising now in the dock. This court has ruled that under Section 3, that is relying on, that it cannot override the constitutional provision. So he has sworn to uphold the Constitution. So it cannot be hard to be arguing point of law from the dock. This one is cancelled. So, my Lord, I urge your Lordship to discountenance whatever it says there. My Lord, that is the first point I made. My Lord, after the plea of not guilty is recorded, my Lord, I refer your Lordships to the third schedule, your order, your rules, that third schedule, paragraph 5.
Yes.
My Lord. Third schedule, paragraph 5. And it says, my Lord, that after the plea of no guilty has been taken or no plea has been made, the prosecutor may open the case against the accused, stating shortly of what evidence he intends to prove the guilt of the accused. So my Lord, that is also in the annex. My Lord, I'm also referring your lordship on section 300. I have a clearer copy. I also refer your lordships to section 300, subsection 1 of the Administration of Criminal Justice Law. And it has the same effect that after the plea of no guilty has been taken or no plea has been made, the prosecutor may open the case against the defendant, stating shortly by what evidence he intends to prove the guilt of the defendant. So, my Lord, that is what I'm expected to do, and also under your lordship's the rules of this court, apart from Administration of Criminal Justice Law. Yes. I intend to discharge my duty by stating briefly the evidence I want to call. Yes. My Lord, my Lord, it's not beside me. He said he cannot stop me, so except that your lordship stop me. So yes, I will do that.
Yes,
This Honorable Tribunal ruled just a few minutes ago that the business of the day was for plea to be taken. Plea has been taken. He has pleaded not guilty. At this point in time, going by the ruling of the tribunal that other applications challenging jurisdiction can now be taken, unless, and I know that I'm before a very honorable tribunal, that the tribunal will keep to its word, that we are entitled to raise those points that are already filed. I don't know, but we have the Constitution. Yeah? Yes, I'll do it. We have, since your lordship, or this, your Honor has ruled, and that represents the law until otherwise set aside, that the proceedings are in the nature of a criminal proceedings. We are then bound to draw your attention to section 36(6)(b) of the 1999 Constitution. Yes. Especially having regard to the preamble made by the defendant in the dock, that he is just coming across these facts for the first time as it was read today. Section 36(6)(b) says, every person who is charged with a criminal offense shall be entitled to be given adequate time and facilities for the preparation of his defense.
That's constitutional provision.
Yes, and it's the paramount provision that governs all of us. We cannot wave it aside. And so, because of its primacy, it is important that adequate time, especially even speaking as a layman, he told the tribunal that he was just coming across these charges for the first time. Rotimi Jacob will tarry a while. Let the Constitution, let him be given adequate time and facilities to brief and instruct his legal team, and I use this opportunity, if you let me leave, to announce the appearance of Malam Yusuf Ali, SAN, A.O. Adelodun, SAN, the brand new silk that the tribunal did not allow me to go and enjoy with him yesterday, KK Eleja, SAN, and Professor Wahab Egbeoli. They are joining the team, so I felt I should announce their appearance while making this application. So I said we need adequate time and facilities to instruct him. Again, I brought him to the tribunal this morning.
Yes.
The warrant did not need, it was not necessary to, I in fact called my land brother Silk at about 5 p.m.
This morning.
No, yesterday, and told him that it would not be necessary for the warrant to be executed. So he's here on his own volition. And having said that the proceedings are in the nature of a criminal matter, but I've checked with the practice of this tribunal. You do not presume that he's guilty until he's proven so, and therefore consistent with the presumption of innocence, and also consistent with the sensitive office he occupies, and the fact that I admit that it was based on my advice to test the law at the higher courts that he had not been here. He has told you that he's a law-abiding citizen. So based on those grounds, on the provisions of Section 163, 164, and 165, and 36 of the Constitution, I'm applying that you release him back to me on bail, on his own self-recognizance, as he will always be the tribunal throughout the proceedings. That's my application. And also for an adjournment, so that we can receive full instructions and then come and argue the application in respect of jurisdiction.
Okay, first thing, the fact you have stated earlier that the defendant actually comes here on his own volition. So we want to say that the earlier order of bench warrant which is hereby vacated. The bench warrant is of no consequence for some. Yes. Prosecution.
My Lord, sir, with respect, my Lord, contrary to what my able learned brother said, that this mic will not work because I'm not mic'd. So the mic is working. So, my Lord, on a lighter note, I confirm that the learned senior counsel informed me yesterday that it will be in court. And following the tradition of the bar, the defendant was not arrested. And learned counsel shows that the president, he was the former president of NBA, and brought him this morning. On a lighter note, I must appreciate him. That is a tradition that we met at the bar, and I pray that that kind of tradition will continue. However, the point I made, the learned counsel didn't come out well. I guess his adjournment he wanted, because he's saying that adequate time and facility. My Lord, the point I raised is not the role to be played by the defendant in any form. What I said, my Lord, I want to state the fact. in accordance with what the law says. So, and that will not in any way affect his presumption of innocence, or issue of fair hearing or adequate time. It's when I state my fact, then he can proceed with his motion. So then, if he has any motion to pursue, because I believe that all those issues that he filed motion for have been raised orally, and the court has ruled on them. So, and they have even filed an appeal on it. The same point they took to Federal High Court, the same point at the Court of Appeal, the same point here. So, my Lord, I want to say, my Lord, that the fact that I state the fact will not take away his right to adequate time and facility to prepare his defense. We have served him more than 7 days. It is not true that he's hearing it for the first time today.
Yes.
So, my Lord, it is not true that he's just saying the charge for the first time here. That cannot be true. That cannot be true. He has filed papers since last week on this charge. So, my Lord, the right to adequate time and facilities, he has been given all the facilities. Even the fact I want to state are the facility that we gave to him. The proof of evidence, everything. The witnesses we want to call. So adequate time and facility that is guaranteed by the Constitution are supported by the rules of court and administration of criminal justice law.
Yes.
So
by the intanglement of the Criminal Administration of Criminal Justice Act is to basically to effectively and efficiently dispense with criminal matters.
Within time, my Lord.
Within time.
Yes, my Lord.
The prosecution will be given opportunity to present.
And it's to be, and particularly Section 396, yes. It's supposed to be day-to-day trial.
Yes.
Where it is Section 396, Subsection 4. Supposed to be day-to-day. So the issue of adequate time and facilities cannot arise. We are here now. He has gotten all the facts. He has gotten all the documents. He has been served with the proof. So, my Lord, so that's my humble reply to what the learned counsel says. My Lord, the issue of bail is taken for granted because I will not stand here to oppose any bail. For we are gentlemen. It's not even bail issue here.
The fact still remains that the defendant having brought himself before us voluntarily, we are not going to say he's not going to go back anyway. He is going back.
Yes, my Lord.
We're not going to hold him. We're not going to ask for any surety. We're not going to ask for any bail.
Yes, my Lord.
He's on his own. He can go back and come back at the next time agenda. But then the most important thing for now is for the prosecution to, in line with the procedure under the commencement of trial before the tribunal, for him to present his facts. Do you have anything to say? But I'm also saying, Ghana Senior Advocate, we are all ministers in the Temple of Justice, and we want to do justice not only to you, but also to the prosecution, and whatever we do, we're doing it for posterity. So we must do what is right.
First of all, due to us, because we are also entitled to justice.
Yes, certainly.
The point is that the Administration of Criminal Justice Act does not override the Constitution. It is the other way around. The Constitution says, give us adequate time and facilities to prepare for defense. Yes. Then we can come on this basis. I have not received any instruction. It will be highly prejudicial for him to go on with this when I have cited a provision of the Constitution. It's in fact, I don't know what he will be talking about.
Okay, I'll ask out.
So the point remains that we need time and facilities. We thank you for the direction on his liberty. All we are saying is that this is the time to go home. Let me take his briefing. And then we'll be here fully. Let's go for Salah and come back. My Lord, back at the Salah in advance.
Lord, I think we have addressed these things sufficiently. I do not think that he has the right to dwell on that in his last address, because the Constitution did not define what constitutes reasonable time, adequate time. The times are prescribed by law, Administration of Criminal Justice law. They are the statutes that define what amounted to adequate time.
Yes.
So, my Lord, it does not derogate from the Constitution itself. So, whereas they came into it. Constitution is a general principle of law that's provided that you must give adequate time. What constitutes adequate time? It's in accordance with the law. The law says these are the things we should do. Immediately after the plea issue, the prosecution should state his case. Immediately after that, he can then ask for the adjournment. But for learned counsel to say that he has not taken instruction after he has filed papers, my Lord, he cannot say that he has not taken. He cannot even be heard from the senior counsel. A counsel filed papers since last Friday to say that he has not received instruction. My Lord, he cannot do that.
Prosecution
He cannot.
We'll give you the opportunity to shortly state the evidence you intend to prove of the guilt of the accused person. Just very briefly.
As the court pleases, my Lord. My Lord, the point which I'm obliged to do is that I'm trying to prove, my Lord,
Yes.
is that the defendant or the accused, as your rule says, he made 4 asset declaration forms.
4 asset declarations.
The 4 asset declaration form.
Yes.
My Lord, and it was those 4 asset declarations form that were investigated. He made one in 2003, 2 in 2007.
Let me take it.
Yes, my Lord.
He made a 4 asset declaration for 1, which was investigated.
Yes, my Lord.
And 1 was taken in 2000.
In 2003,
In 2003, yes.
yes, my Lord. Another one was made on 11th July 2007, 2007.
2007.
Yes, my Lord.
Yes.
So he made the same asset declaration form, the 3rd one, in 2007.
In another 2007.
Yes, my Lord. That is, there are 2 asset declaration forms that he made
In 2007.
in 2007.
Yes.
My Lord, the final asset declaration he made was in 2011 June. My Lord, before this charge was filed, these are the only asset declaration form with the Code of Conduct Bureau.
Yes.
As at the time when this charge was filed. These are the only 4 asset declaration form. My Lord, in those asset declaration form, my Lord, the prosecution will lead evidence. My Lord, the asset declaration form are also in the proof of evidence. We annex them to the proof of evidence.
Yes.
All the asset declaration forms that he filled. My Lord, all the properties, my Lord, your Lordship will observe from the asset declaration form he made in 2003, the defendant claimed that he acquired number where is this child? He acquired number 15A and 15B McDonald Ikoyi in 2003, my Lord.
Rotimi, I don't think that's what the law requires you to do. Give us a summary of what is involved.
No, that's what I'm trying to do.
No.
Maybe I'm going too deep.
You are going too deep. We don't need that now.
As the complices. My Lord, we will call only 5 witnesses to prove our case. And we will show to your lordships that the defendant made an anticipatory asset declaration. He said he acquired property in 1996, and he filled it in 2003 in his asset declaration form. Whereas your lordship will see the title document of the same asset from the proof of evidence, where the presidential committee, headed by the then minister El-Rufai, sold the same property to him in 2007. The title is not a political statement. Well, my lord, that is to show the morality of our nation today. It's a sad day. It's very sad. Very sad. Very sad indeed. Very sad. So, my lord, apart from that, we will also lead evidence as to property acquired while he was governor between 2003 to 2011. All the assets he acquired, and because he acquired those assets while he was governor, he never declared those assets. So, and we discover and we got the title documents. They are also in the proof of evidence. The account he opened, how he moved money out of Nigeria to UK, to United Kingdom, and to London. We will also lead evidence to that. My lord, we just need 2-3 days to open our case and to conclude and close our case. So, my lord, I'll be urging my lord to give us 2 clear days prior. Yes, my lord.
All right. Last says, Rotimi.
Yes, my lord.
Are you done?
Yes, my lord.
Yes. Having said that, and having read the plea to the accused person, he has not pleaded guilty, and then having joined issues by the both parties, so we will take a date now.
Yes, my lord.
So that you will come and produce and submit your state your evidence, and then of course the opportunity will be given the defense to examine all their witnesses, and then we'll proceed.
As a complices.
So all we need now is to have a clear day within which we can come and deal with this issue.
As the complices, my lord.
Yes.
We are grateful, my lord. I was thinking that they will be ready. I have my witnesses here. I was thinking that they will be ready. Yeah, yeah. Yeah, yeah. Yeah, yeah.
Please. We want to say that we're still not mindful of the fact that the defense, we do believe, have some applications to move before us. Is that correct? We will not shut them down. Whatever it is, we will shut them down. We will not shut it down. We'll give them the opportunity to state the application, and then we'll now take it, and then at the same time proceed with the substance of the matter. So we'll take a date within which all those issues can be conversed.
As the complices,
yes. We should take a reasonable time within which, as the defense, yes, of course, under Section 36 of the Constitution, they are entitled to adequate time. So that adequate time we should be giving to them.
Complices, my lord.
Yes, yes. So I want you to agree on a date. and then you liaise with the registry and see the, yes, we agree on the date.
One 953210 to the American Express Service Europe Limited, number 730580 for onward credit to your American Express Bank, New York. Card account number 374588216836009. And you thereby committed an offense contrary to paragraph 3 of part 1, fifth schedule, to the Constitution of the Federal Republic of Nigeria as amended, and section 7 of the Code of Conduct Bureau and Tribunal Act